Welcome everyone. I'm John Howe. I'm the Director of the Melbourne School of Government and Co-Director of the Centre for Employment and Labour Relations Law at the University of Melbourne. And on behalf of the Melbourne School of Government Social Procurement Program, the Centre for Employment and Labour Relations Law, and the Labour, Equality and Human Rights Research Group at Monash, I'd like to welcome you today to this webinar on federal government procurement and the implementation of modern slavery legislation. I'd just like to note that the webinar today is being recorded, and we will share the recording after the conclusion of today. But just be aware that the webinar is being recorded. Before we begin, I'd just like to acknowledge the traditional owners of the lands upon which we're all attending this webinar. In my case, that's the land of the Wurundjeri people of the Kulin Nation, and I'd like to pay my respects to their elders, past, present and future, and also to any Indigenous people attending the webinar today. I'd also like to introduce my co-presenter today, Dr. Ingrid Landau from the Monash Department of Business, Law and Taxation. And among other things, Ingrid's a member of the Australian Universities Procurement Network Modern Slavery Academic Advisory Group. Okay, so what Ingrid and I are going to be sharing the presentation today, and what we're going to be talking about is the Australian government's approach to its compliance with its own legislation, the Modern Slavery Act 2018, which, as I'm sure you all know, requires large Australian organisations to report annually on measures they've taken to identify and address risks of modern slavery in their operations and supply chains. Now, unlike the UK version of this legislation, the Act expressly applies to the Australian government, and the findings we're presenting today are from a paper we've written analysing the federal government's response to that legislation, and that paper will be published later this year as an article in the Sydney Law Review. But if people are interested in that paper, please email me or Ingrid, but otherwise we'll let people know when the paper is actually published. The Australian government is committed to a global leadership role in combating modern slavery through the enactment of this legislation, but also by taking that step of making the government itself subject to the reporting legislation. And this is in the context, of course, of the growing international interest in the use of public procurement to promote respect for human rights. While under-examined in the literature to date, this feature of the Modern Slavery Act, that the Australian government's subject to its requirements, is significant because of its potential impact on federal government procurement processes and through these on business practice. The Australian government is the largest procurer in the Australian market. In 2021, it entered into over 84,000 contracts with a total value of $69.8 billion. And the application, beyond that influence, the application of the Modern Slavery Act to the Australian government may also prompt innovation and reflection with respect to the use of public procurement as a means through which to promote respect for a broader set of human and labour rights. So that's the broader context. In our presentation today and in our paper, we've looked at how the Australian government has sought to integrate modern slavery considerations into its procurement processes. And we've looked at how effective we think these efforts are likely to be from a labour regulation and compliance perspective. And what does the Australian government's approach tell us about how the federal government conceptualises its regulatory role within the context of public procurement and labour governance? We've taken very much a focus on regulatory design. So we're not looking at whether or not this is a desirable step, or whether or not, you know, the initiatives are legal in domestic or international law. We're interested in whether they're designed in a way that's going to work in terms of the broader goals of the Modern Slavery Act, which is to eradicate modern slavery practices from supply chains of large Australian businesses and the Australian government. In adopting this labour regulation and compliance perspective, we conceive of the notion of regulation quite broadly. So, in other words, the practice of attaching conditions to procurement relating to labour, social procurement, sustainable procurement, Indigenous procurement, is a form of regulation in that the use of purchasing is designed to try and leverage some other policy objectives. And we also note that this is going to involve government, but also the suppliers to government, but also often non-state actors who are also involved in procurement and supply to government. And so we're going to look at the challenges of securing compliance, the efforts made by the regulatory authorities to elicit compliance, and how the regulation is responded to and implemented by those individuals and organisations to which it's directed, or that's at least within our interest in procurement as a form of regulation. And we know that in procurement, there's often avoidance of the notion of compliance, but in reality, if government is attaching conditions to procurement, then it is really using procurement as a form of regulation, and we need to look at it from that perspective. Often in the context of procurement, the strongest debates are around whether social policy, sustainable policy should be adopted as part of a procurement regime, because the traditional focus of government procurement is around value for money, more in a narrow economic sense of cost benefit. So the focus tends to be on whether or not the social or other goals should be adopted. There's less attention to the actual implementation of these procurement policies once they are adopted. And so that's been our focus in our study on the federal government's implementation of the modern slavery legislation. Now we see there are two distinct sets of regulated actors and entities that merit attention in this context. The first is inside government. So since the late 1980s, the Australian government has increasingly adopted a more decentralised approach to government purchasing. Whole of government purchasing arrangements remain in certain areas, but otherwise, beyond these areas, individual Commonwealth entities are responsible for their own procurement policies, procedures, and conducting individual procurements. However, this devolution of responsibility doesn't mean that there isn't any regulation, if you like, of of that decentralised procurement. So there's a range of statutes and also the Commonwealth procurement rules, which seek to regulate how all those procurement decisions are being made. I just wanted to pick up that in the Commonwealth procurement rules, there is these leave procurement officers with significant discretion in their decision making. There is a rule that requires office officials to consider regulations and/or regulatory frameworks relevant to procurement, including labour regulation and ethical employment practices. But the discretion granted to procurement officers under that rule is very broad. So it's largely left to officers to make inquiries as to what the meaning of that requirement is in a particular context. There is some further guidance from the Department of Finance on that, but it still leaves officials with a lot of broad discretion about how to satisfy themselves that that requirement has been met. And so, for example, they may simply require successful suppliers to provide assurance of their compliance. That may be through an independent audit report, or they may conduct their own investigations as to whether the requirement's being met. But it's not mandated by the rules. Public inquiries and academic studies have consistently found that the overall effect of this regulatory framework, along with the consistent pressure on departmental and agency budgets, has tended to promote a culture that prioritises cost and risk minimisation rather than a wholehearted compliance or observance of some of these types of labour, for example, criteria. The second group of actors we need to think about is regulating business. And so the government itself, in its first modern slavery statement, said that the initiatives are intended to leverage the government's unique position to influence the conduct of suppliers and market practices to drive positive change, which raises this question of regulatory effectiveness. So is the adoption of this practice in the context of the Modern Slavery Act actually having an impact on suppliers and the presence of modern slavery in their supply chains? And in looking at this question about procurement as regulation of business, we've adopted a framework which is commonly used in assessing the likely effectiveness of regulation, in that we've looked at what's the process by which standards or principles to be applied are adopted, what's the process by which observance of those standards is monitored and information about non-compliance fed back into the regime, and enforcement, to what extent is action taken to hold the regulated actors accountable to the standards. And unless you've got appropriate mechanisms in all three of those categories, you're less likely to have effective regulation. So at this point, that's our kind of framework, and I'm going to hand over to Ingrid to speak about how the government's applied its obligations under the Modern Slavery Act to date.
Okay, thanks, John. So John's kind of emphasised, I guess, that what we argue to be two distinct sets of challenges in this space that are often overlooked or conflated The first one is regulating procurement officers' decision-making, and the second is regulating business practices. And that's the framework that we consider recent initiatives through. So I'm going to move on to look at how the Australian government's introduced modern slavery concerns into its procurement functions. And I want to start with just a brief overview of the Australian government's 2 modern slavery statements to date, before going into some of that detail. So as John mentioned, the key driver for the Australian government's recent activity in this area in public procurement has been the Modern Slavery Act. The government has published to date 2 modern slavery statements under that Act, and they're publicly available on the Modern Slavery Register. In both statements, the government has kind of professed its commitment to leading by example in addressing modern slavery risks in its operations and supply chains. Both statements are structured according to the 7 mandatory reporting criteria in the MSA. The initial statement, 2019-20, details the risk scoping exercise that the Australian government's undertaken in conformity with its own guidance that is produced for reporting entities. It identifies 4 areas of procurement that it considers to have a particularly high risk of modern slavery: textiles, construction, cleaning and security services, and Commonwealth investments. The first statement discusses these risks in general detail, and also identifies 5 areas in which the government is taking action. 2 of these areas are relevant for our purposes: embedding modern slavery considerations in public procurement processes and educating public procurement officers so they can assess and address modern slavery risks. In its most recent statement, the second one, the government elaborates on the modern slavery risks in its priority sectors and also considers modern slavery risks in the context of ICT hardware. According to the government, it's focused in its second reporting period on collaboration with industry and civil society experts to build a deeper awareness and understanding of the nature of modern slavery risks in its high-risk areas. Helpfully, the 2020-21 statement explains the government's continuous improvement approach to addressing modern slavery risks, including its procurement. And this approach involves 4 phases of action. So currently we're in the discovery phase, in which the government is undertaking targeted supply chain mapping and risk assessment to increase visibility and awareness of modern slavery risks. This will be followed by a 2-year implementation phase, and then finally a review phase in 2025. So what does all this mean for federal procurement? So as the government's explained in its initial statement, it has sought to integrate modern slavery considerations into existing rules within the CPR, which John has already mentioned. Specifically, into the general, it argues that modern slavery belongs within the general prohibition on entities seeking to benefit from supplier practices that may be dishonest, unethical or unsafe. Rules in Division 1 that apply to all procurements. And also the need for officers to make reasonable inquiries that procurement is carried out considering relevant regulations or regulatory frameworks. And this rule is in Division 2, which applies to larger procurements. So to help implement this Rule 6.7, the Commonwealth already provides model contract clauses that require suppliers to comply with existing laws that are in existence from time to time in any jurisdiction in which that part of the contract is performed. And there's an additional model clause which is available, which requires supplier compliance with Commonwealth laws and policies, and for the supplier to provide such reports and other information regarding compliance as reasonably requested by the customer or as otherwise required by relevant law or policy. Covered procurements, that are those covered by Division 2 as well, must comply with Rule 10.19, which is on the slide, which John has discussed as an example of the discretion granted to procurement officers by the drafting of the CPR. Rule 10.9, as John mentioned, requires officials to consider regulations and or regulatory frameworks which are relevant to the procurement, including tenderers' practices regarding labour regulations and ethical employment practices. There's a Department of Finance guidance that elaborates upon this rule, and it explains that procurement officers should determine for themselves how best to satisfy the rule. They should use their own judgment when determining what constitutes a relevant regulation and/or regulatory framework, and where unsure, seek advice internally or externally. It's also up to officials to determine how they go about monitoring compliance with this rule. So building on these broad and pre-existing rules within the CPR, the Australian Border Force has produced a suite of resources to assist Commonwealth procurement officers identify and respond to modern slavery risks in current and future procurements, as well as to influence change in the private sector. These resources, all which are optional, include a risk screening tool, a supplier questionnaire, and modern slavery model clauses. And they're assembled together with tender guidance in the document which is on the slide for you. I'm just going to refer to as the toolkit. It's actually the Addressing Modern Slavery in Government Supply Chains, a toolkit of resources for government procurement officers. Unfortunately, we don't have time to go into detail about how the various tools in this toolkit are intended to be used, but the figure on the next slide, on the right-hand side, shows when and how the tools fit within the three main stages of the procurement process. We do analyse these tools in some detail in the paper, and really the takeaway from our analysis, I think, is that while these resources are no doubt well informed and provide useful advice on integrating modern slavery concerns into procurement decision-making, they leave procurement officers with broad, if not unfettered, discretion to decide whether modern slavery considerations will be taken into account in relation to a tender or an existing contract, at what stage in the procurement process any such considerations will be taken into account, and broad discretion in terms of how such integration of modern slavery concerns is to take place. The government, as I mentioned, has also produced free model contract clauses that can be included within public contract. Use of these clauses, again, is optional. However, procurement officers are encouraged to consider using the strongest modern slavery clauses in all procurements to drive increased awareness and accountability. They are also encouraged to foster continuous improvement by including further requirements at the contract renewal and review stages. So as you can see from this slide, which probably could be prettier, sorry, that's my fault, the three clauses have graduating obligations that agencies and officers can select depending on basically the risk profile of the procurement. The short form is recommended for contracts where the risks of modern slavery in the relevant supply chain are considered low. It has two main obligations: that the supplier take reasonable steps to identify, assess and address risks of modern slavery, and that it take all reasonable steps to reasonable action to address or remove these practices once they're identified. The standard clause imposes additional obligations. There's a requirement on suppliers to ensure personnel responsible within the supplier receive modern slavery training. Suppliers are also required to prepare, implement and comply with a modern slavery risk management plan. This plan should detail, at the minimum, the supplier's steps to identify and assess risks of modern slavery in its operations and supply chains, the processes for addressing any modern slavery practices identified, the content and timing of modern slavery training, and details of a grievance mechanism available to personnel. There are also some additional obligations, as you can see, including prohibition on requiring personnel to pay recruitment fees, and prohibition on destruction or exclusive possession of travel or identity documents. The long form clause is advised for procurements assessed as having a higher risk of modern slavery, and officers are advised to use these for clauses of high value or high risk. The clause builds on the standard clause, but includes a right for the customer, so the government, to review and suggest amendments to the supplier's prepared modern slavery risk management plan. It also requires the supplier to notify the customer of any modern slavery practices that it becomes aware of and actions taken. The toolkit kind of encourages procurement officers to foster collaborative relationships with suppliers and to work in partnerships to monitor compliance and provide support when needed. Procurement officers are also advised to monitor supplier compliance through processes such as regular contract meetings, audits, and KPIs. Right of termination, the guidance recommends, should only be exercised in relation to material breach of a modern slavery contract clause where the supplier has repeatedly and deliberately disregarded the terms of the clause or demonstrates no intention of engaging with the government entity to remedy the breach. I'm now going to pass back to John to begin our discussion on some of the prospects and limitations of the government's toolkit approach and the model clauses.
Thanks, Ingrid. And I should have said at the outset, as noted in the chat, if you've got a question, please post it in the Q&A, and we're going to leave some time for discussing questions at the conclusion of the webinar. So the implementation of the Modern Slavery Act has led to some positive developments in federal public procurement. So through its application to the Australian government, the Act prompted the Commonwealth to regularly collate information on the scope of its operations and supply chains, as well as on relevant policies, procurement policies and practices, and to present this in an accessible form. There's also been, to some degree, an enlivening of those Commonwealth procurement rules that require procurement officers to consider the presence of unlawful and or egregious labour practices that may otherwise have been overlooked or tolerated. Procurement officers, in addition, can now avail themselves of a toolkit which provides advice tailored to the public procurement context on identifying, assessing and responding to modern slavery risks during the tendering and contract management processes. And model clauses are available for adaptation and inclusion within government contracts. Efforts are also underway to improve procurement officers' awareness of modern slavery and modern slavery risks in the goods and services they purchase. However, we identify in our paper a number of limitations to the government's approach so far, but also prospects for steps that could be taken to improve the effectiveness of the implementation of modern slavery legislation. So there are 4 sets of concerns set out on the slide. Concerns around the scope of the government's efforts, the extent to which the measures suggested in the toolkit will be effective given the broad, almost unfettered discretion given to procurement officers, issues around expertise and resourcing, and in relation to monitoring and enforcement. I'm just going to speak briefly about the first two of these and then hand back to Ingrid before we conclude. The Australian government's focus on modern slavery-related risks within its supply chains, while that's understandable in the context of the Modern Slavery Act, is limited in its scope in 2 ways. First, it doesn't appear to adequately address or seek to address the broader conditions that enable severe forms of labour exploitation to exist in the first place, with the exception of the general prohibition on recruitment fees and the retention or destruction of identity documents in the standards and long model form clauses. The government does not appear to be taking additional steps to identify or address broader labour rights violations or poor working conditions in its supply chains, despite the fact that these factors are widely acknowledged to heighten worker vulnerability to extreme forms of labour exploitation. The second issue with scope is that the exclusive focus on modern slavery risks falls short of meeting the expectations of the international community when it comes to measures adopted by the state to address potential and actual human rights abuses in public procurement. In relation to the second issue there, around regulatory discretion, the Australian government's approach to the integration of modern slavery considerations in its procurement is striking for the broad degree of discretion, as we've noted, it affords entities and procurement officers. Use of the toolkit is encouraged but optional. The toolkit itself makes it clear that it is up to procurement officers to determine not only the extent to which they take modern slavery considerations into their decision making, but how they do so, what specific standards they require, and how any such standards are monitored and enforced. There are no minimum mandatory requirements, even when the procurement is deemed high risk of modern slavery. There is not even any explicit prohibition on engaging suppliers that are not in compliance with their reporting obligations under the Modern Slavery Act. So this broad discretion, in a context when we understand that procurement officers have a lot of different rules and requirements to apply and are often, under time pressure, leave scopes. There's definitely a risk of a minimal approach being taken. Of course, there are also opportunities for procurement officials to innovate, to tailor contracts to specific contexts and suppliers, and to experiment and innovate. And it's hoped that that innovation takes place, but there's also the risk of the more minimal approach being taken. Over to you, Ingrid, to discuss those final two areas.
Great, thanks, John. So our third area of concern relates to expertise and resourcing. To be meaningfully implemented, the two relevant rules within the CPR and the toolkit itself require procurement officers to have commitment, expertise, and adequate resourcing. The Australian government has recognised the need to enhance procurement officers' awareness and understanding of modern slavery and their capacity to make more informed procurement decisions. It's developed 2 online modern slavery training modules for procurement officers, and individual non-Commonwealth corporate entities already also have taken their own educational initiatives. For example, the Australian Tax Office has developed a modern slavery help card for its procurement officers. However, I think it's fair to say it's unclear whether these resources will be sufficient to equip procurement officers with the expertise necessary to implement the measures proposed in the toolkit effectively. And importantly, I think there's no indication in either of the modern slavery statements produced by the government that procurement officers have been given any additional time or resourcing to meet these new expectations. And I think the question of appropriate expertise is particularly salient given the requirements in the standard and the long form model clauses for suppliers to develop and implement a modern slavery risk management plan. So from a regulatory perspective, requiring suppliers to develop their own management plan, of course, has its advantages. It recognises the complexity and the diversity of suppliers. It recognises that the regulator, the procurement officers might not know exactly what they're asking the supplier to do, or and so on. And it recognises and encourages continuous improvement by suppliers. So this kind of risk management plan approach has its benefits. However, we know from the regulatory governance literature that the effectiveness of this kind of risk management plan approach is contingent upon appropriate oversight of a plan's quality by an appropriate regulator. And under the Australian government's approach, the regulators are the procurement officers themselves. It's open to these officers to simply accept any plan that is provided to them as adequate evidence of compliance. Hopefully, of course, some attempt will be made to assess the validity and the effectiveness of plans that are submitted by suppliers. but it's unclear how this is to be done or against what criteria. And we suggest, as John's mentioned already, that given limited expertise and time and resource constraints, there's significant risk that officers will simply adopt a tick the box approach to these plans. And this would be highly undesirable, as it would simply foster more cosmetic compliance towards modern slavery risks that we're also seeing in other areas. And in our paper, we elaborate on the risks associated with this compliance plan or a risk management plan approach by drawing on the experience of the US government when it's implemented the anti-trafficking provisions in its Federal Acquisitions Register, FAR. So it adopts a similar compliance approach, and successive inquiries by the Government Accountability Office, the GAO in the US, and the Inspector General of the Department of Defense have found significant problems with the implementation of the compliance plan approach to anti-trafficking and slavery in US procurements. And in short, it's found consistently that these provisions have not been implemented effectively because procurement officers responsible for them have lacked the requisite expertise, knowledge, and commitment to do so. Our final set of concerns goes to monitoring and enforcement. So the regulatory literature obviously emphasises the importance of monitoring and enforcement to any effective regulatory regime. And we think if the government is serious about including modern slavery related obligations in its procurement contracts, then it should put in place monitoring and compliance related mechanisms. Otherwise, these kind of initiatives are kind of merely window dressing. However, we know from international research, again, that monitoring and enforcement of labour and human rights provisions within public procurement contracts are kind of the weakest area of this in this area. For example, a 2016 survey of 20 jurisdictions and their use of public procurement to promote human rights found that systematic and comprehensive monitoring of performance with regard to human rights amongst government suppliers was not identified in any of the surveyed jurisdictions. We're not aware of any similar surveys in Australia, but we can draw analogies from other areas. For example, the National Auditor General has looked into Commonwealth government requirements for non-Commonwealth corporate entities to apply mandatory minimum targets for Aboriginal and Torres Strait Islander participation in major projects. And the Auditor General found that the ineffective monitoring was a key factor undermining the effectiveness of this initiative. So while it's perhaps unsurprising to find that the Australian government's modern slavery related procurement initiatives place little emphasis on monitoring and enforcement, we do think it's of concern. While there is, certainly in the toolkit and other places, suggestions and alternatives for procurement officers to use their discretion to adopt compliance mechanisms and monitoring mechanisms, we think that the clear kind of emphasis placed on cost considerations within the CPR and other constraints mean that procurement officers are likely to opt for cost neutral forms of monitoring, such as requiring suppliers to basically self-monitor and report any instances of suspected non-compliance themselves. The model clauses also promote self-monitoring and self-reporting. As I mentioned before, the toolkit says that procurement officers can choose to undertake additional monitoring by way of regular contract management meetings, audits, and the use of KPIs, but it's unclear what motivation procurement officers would have to do this, how any additional information provided by the supplier would be verified or used by the officers, and how audits would be used in this context, or what KPIs would be useful and appropriate. Again, we can draw on kind of experience from the US, which has showed that despite requirements for them to do so, procurement officers in the US, the overwhelming majority that were interviewed for a particular study did not conduct regular monitoring or evaluation of contractor compliance with the relevant human trafficking and slavery requirements. And procurement officers cited reasons, including a lack of awareness of their responsibilities, a lack of adequate know-how, or the attachment of low prioritisation to these responsibilities. Of course, it's unrealistic to expect procurement officers to be out there on the ground monitoring contractor practices themselves, and we're not suggesting they do so. But there are certainly examples from Australia and internationally of ways in which monitoring of labour-related standards in public contracts can be undertaken meaningfully if the requisite commitment is present. And we talk about these examples in our paper. Just to wrap up, I guess, what we've tried to do today and in our paper is to contextualise and describe the government's modern slavery related procurement response over the first 2 reporting periods of the MSA. And we've also sought to evaluate this tentatively, obviously recognising that it's early days, from a labour regulation and compliance perspective. We do think that the Australian government's initiatives have a lot of promising elements. However, we've also kind of identified features of the government's response that we have concerns may limit their potential effectiveness. Because it was our 3rd research question on our slide, I'm going to very briefly, in 1 minute, address our 3rd question and conclude with a brief reflection on the role of state purchasing in promoting and securing respect for labour rights transnationally. It's been observed that in the 21st century, there's been a shift in focus, or an expansion of focus, from looking at the state as rule maker and model employer to also looking at the state's role as a model buyer. Yet to date, while we've got plenty of literature looking at how private organisations, businesses can successfully leverage their purchasing power to influence change in working conditions in their supply chains, we really don't have much at all of literature on how states can do so. And I think there's a lot of we talk about this in our paper, John and I, we think there's a lot of important questions about the extent to which governments are willing and able to leverage their significant purchasing power in the context of a very highly decentralised public procurement system, where they're also at the same time pleading that they can't do much because it's too decentralised. And I think another important question concerns the desirability, I guess, of public procurement authorities perhaps starting to adopt the kind of private compliance initiatives or techniques, such as social auditing, that we've seen prevalent in the private sector. I think finally, just to finish off, I think the reality is that we just, from an empirical perspective, understanding how procurement officers, I guess, those responsible for implementing and enforcing these types of provisions, is central to understanding how effective the regulatory regime is. And we simply just don't know how procurement officers manage the multiple demands upon them, particularly in relation to cost and social procurements, how they manage contractual relationships in cases of suspected non-compliance, and also the impact of different approaches, such as the risk management plan approach, on supplier practices and ultimately on working conditions. So I guess ultimately it's our hope that the Modern Slavery Act and its prompt on the Australian government to begin to address these issues will prompt greater engagement by policymakers and scholars with these types of questions. Thank you.
Thanks, Ingrid. Now we've got one question in the Q&A. Ingrid, the question from Evelyn is, public sector agencies such as the NLA have been using labour hire arrangements to meet business needs. How can the government give guarantees that they are fulfilling their current employment obligations? Well, I guess what we're saying is, in terms of the Modern Slavery Act, or even, the application of the CPR Rule 1019, there's it really depends on the extent to which a procurement officer seeks to verify compliance. But yes, in answer to Evelyn's question, I think it does. I don't think the government can guarantee that unless it's, adopted a rigorous process to verify the supplier's compliance. So if it just accepted the labour supplier's word that it was compliant with its employment obligations, then that's going to depend on how accurate that assurance is, and it's hard for the government to guarantee that if it hasn't done its due diligence. Ingrid, is there anything you want to add to that?
No, I mean, I think if the question is about the extent to which the government is relying on labour hire or indirect employment rather than, I'm a bit unclear, then obviously that's a very important question, but not within the scope of our paper. I think from memory as well, I'm not sure if labour hire is one of the coordinated procurement arrangements that the Commonwealth has, in which case, of course, it is open to the Commonwealth to attach a range of other conditions to labour hire contracts.
Yep. Okay, we've got another question from Jenny. When is the paper coming out? And will you be putting in a submission to the Modern Slavery Act review? Well, we're hoping the paper will be out later this year, but we can't give you a definite date yet. But we hope it can be available in an early release form within the next month or two. Ingrid, we don't have any other?
No, I think it was the June or September issue, but we can certainly share a draft. Will we be putting submission to the MSA review? My concern is just we will only put in a review if we don't. My approach is if it's not going to be covered by many other people anyway. I'm not sure to what extent the review, if it's a review on the efficacy of the Act, I'm not sure to what extent this is relevant, to be honest, but the government's own procurement actions. But I also think, I mean, there's other limited scope, I guess, to put to offer submissions or comments on the Australian government's own approach, so it may be relevant. John, you might want to add to that.
Yeah, look, I'm happy to put the paper in as a submission, and they can consider, the relevant aspects of it. The next question also relates to the review of the legislation. What do you think we'll see coming out of the upcoming review? I suspect the answer to that will depend on what happens next Saturday, but Ingrid, do you have any?
Yeah, look, I don't have any particular insights coming to other people there. I imagine we'll see some more, there's some great evidence, empirical work coming out, like the recent work done by the Coalition of Civil Society and Academics, looking at how seriously companies are taking their reporting obligations, which suggests that in many cases they aren't taking it particularly seriously. And so I think all that evidence will help, and we will probably see, I imagine, some changes to penalties and so on. I think one of the interesting questions in the procurement context as well is the question of the absence of any kind of regulator or body that can assist or advise or provide scrutiny of that might assist procurement officers and agencies in their administration of the modern slavery related requirements. We talk about this in the paper, the extent to which in some other areas, for example, we don't like to use this example so much, but building construction industry, where there were procurement related requirements, you had a regulator, the commission, Building Industry Commission, that would actually help the government apply those procurement related clauses. So to the extent that we might see some kind of regulator in the national context in the modern slavery, which we have not, because to date, a modern slavery commissioner, then that kind of role might help in the procurement context as well, I think. So we might be able to include that in the submission now I think of it, John.
Yes, we should. And there's a related question from Lisa Heap. State governments, such as in Victoria, using procurement requirements for a number of social obligations, priority areas of action, such as gender equality targets in construction. Are there any regimes in the state government areas that may demonstrate useful models? And we do look briefly at the workplace gender equality procurement principles in Victoria as a model, because the Workplace Gender Equality Agency does play a role in verifying, I think, compliance in that case. So yes, and I think you know, there may be disagreement about the focus of the building, you know, the ABCC approach and the thrust of the building code, but actually as a regulatory model, it's an interesting and somewhat effective model for procurement regulation. So definitely agree it's worth looking at other regimes for interesting ideas. Petra asked a question about whether we see any difference in Australian public procurement regulation and processes, where the supply chain is in Australia compared to chains or parts of chains that reach overseas. Do you want to take that one, Ingrid?
Well, I think one of the real benefits of the Modern Slavery Act is that it has compelled the Australian government to kind of basically, for one of the first times, actually encourage procurement officials to consider labour and human rights risks in contracts that extend beyond our shores. We've seen in a range of examples over the last 20 years, procurement initiatives at the federal level that come and go, depending on the politics, but that have sought to some way address labour standards within Australia. But we've really seen very little that extend beyond our shores. So I think that is a real positive effect of the Modern Slavery Act. If the question is, I'm not sure whether, or the question could be, does any of the regulations make a distinction between compliance with domestic laws and laws internationally concerning labour standards? And the answer is kind of no. But the problem with that, of course, is that you're presuming that the procurement officers have some notion of what laws the supplier is expected to comply with in whatever jurisdiction. And I think, and that's another example, based on the US kind of studies looking at the implementation of the FAR, was that procurement officers had to, were supposed to implement and monitor a clause that required suppliers to comply with all labour laws in which jurisdictions they operated. But the procurement officers, when asked, couldn't say what laws applied. So there was no chance that they were going to be able to say, that they were implemented in any way. So I think that's interesting as well.
Tess asks, in our view, what are the optimal mechanisms for monitoring compliance, particularly where the business that has the direct contract with government has outsourced some functions to subsidiary firms? Well, I mean, I think there's a range of approaches that have been taken. You're probably better at reviewing those than us. But I think, obviously, if you had a well-resourced agency that has that responsibility, that could be one approach, and they're doing a more rigorous kind of assessment of not just the contractor but its supply chain. And then you've got other approaches where there's an audit obtained by the contractor of its supply chain. And then you've got third-party auditing where it's not the government and it's not a self-audit, but it's perhaps a not-for-profit agency or a union that's reviewing the supply chain, and that has kind of some presence if it's offshore, if there are offshore suppliers in the supply chain.
Can I just add to that, John? I think one of the obviously the fairly common models in this area is the kind of the multi-stakeholder initiative to, as John said, using third parties to engage in monitoring compliance related activities. And I think what's really interesting in the Australian government context, and there might be people, I can't see who's in the room, so might be people who know more about recent developments in this space than I do, but based on the Australian government's modern slavery statements, what's interesting is to see the Australian government is engaging with two kind of well-recognised sector-specific initiatives, Electronics Watch, which focuses on worker labour rights in the electronics industry, and CAF, the Clean and Accountability Framework within Australia, which focuses on working conditions in the cleaning sector. But according to the government statements, so far the Australian government has only engaged with those initiatives to ascertain and understand more about the nature of the risk. They haven't reported any ongoing engagement with those initiatives in terms of the monitoring and compliance activities. So hopefully we will see more of that.
Okay, so we've got two more questions and then we'll finish up because it's 2 o'clock. Warren asks about, in relation to building on Petra's question, whether we have any thoughts on whether modern slavery issues within Australian supply chains involve wage theft. Well, they may do, but of course, the first one of our comments around the scope of the Modern Slavery Act and the government's obligations under it is that modern slavery is defined as trafficking in persons, slavery, servitude, forced marriage, forced labour, debt bondage, the worst forms of child labour, and deceptive recruiting for labour or services. Now, some of those practices are going to involve wage theft, but underpayment of workers that don't fall within those categories are not specifically within the scope of the Act. Now, in the Australian context, that rule in the Commonwealth procurement rules does essentially require procurement officials to verify that Australian labour law is being complied with, but the same issues we've raised, and there may be wage theft going on, but the same issues we've raised about adequate monitoring and verification apply. Ingrid, is there anything you wanted to add on that?
No.
And the final question from Greg, are any state governments involving modern slavery elements in their procurement processes? Ingrid?
Very good question. I should know the answer to this. I believe New South Wales and Western Australia, but I would have to confirm that. But again, that is certainly, it's a very good question and something that we should look at, and there's certainly scope for another paper comparing state and federal government responses in this area.
Yeah. And look, I think it's an interesting question because, of course, those areas defined as coming within the scope of modern slavery are mostly areas that in the domestic context are already regulated. And I would say most states would have a requirement that contractors need to be compliant with, for example, child labour laws to contract with the government. So most of those areas would probably be covered by that kind of general compliance requirement. But I would say perhaps beyond New South Wales and WA, the states wouldn't have a specific focus on modern slavery in their procurement policies. But an accurate answer on that will have to be given on notice, I think. Fiona notes that Victorian government's framework includes a focus on labour standards. Yep. And Jenny's included a link in the Q&A to the New South Wales modern slavery and procurement policy, I assume. So thanks, Jenny. Thanks, Fiona.
Yes, thank you.
But I mean, I think it is an interesting question. Is it better to have the focus on some of the more egregious labour practices? And because I'm not sure that that general kind of labour compliance requirement that state governments might have, or even at federal government level, is really being rigorously applied and monitored. And the focus, I suppose, on modern slavery does give a bit more emphasis, and the reporting gives a bit more visibility on what's happening. Anyway, look, thanks everyone. We really appreciate you all attending. As I said earlier, we will post the video recording of this online. So let people know if you found it interesting and if they might want to see it, and we'll do that as soon as possible. And we'll see you all soon at another webinar or seminar, I hope. See you later.
Thanks, everyone.